right, thank you, Madam Clerk. Call the next case, please.
State of Tennessee versus Ginny Elizabeth Parker.
All right, Mr. White, good afternoon.
Good afternoon, Your Honor. And if I could go ahead and reserve 5 minutes for rebuttal, I'd appreciate that.
That'll be fine.
Your Honor, I believe this is a bit of an unusual case today. I have practiced for 10 years. I've never heard of a situation where somebody's found guilty, the guilty plea is then withdrawn, and then the person's found guilty again for the same reasons, Your Honor. And that comes to a procedural pattern where the trial was in September of 2021. The court set a final date of November 12th, 2021 to enter a verdict. Sua sponte, the court reached out and reset it for November 19th before docket call, announced that it was withdrawing the guilty verdict and was subject to a question by counsel, which is in volume 7 of the record, page 9 and 10. And it's also in my brief, but it specifically addresses the question that was asked, which was my question, which was the fact that we are still here, still tortured over this issue. And the court interrupted and said, yeah. Would that not be reasonable doubt? And the court responded, well, that's kind of what I just said. Now, the court expanded upon that as well, Your Honor, but the court is at this point, because of a bench trial, the trier of fact. And the trier of fact is admitting that they are not resting easy by withdrawing that guilty verdict within 1 week. It was almost, in the eyes of the law, an immediate withdrawal, Your Honor. I believe the court still had jurisdiction to withdraw the guilty verdict because it didn't become final for 30 days. However, I do question whether the judge can withdraw it, go 90 more days, and then find them guilty a second time, or whether or not this was sufficient to establish a reasonable doubt on the November 19th hearing, and essentially, in a quantum Merowit situation, the court has admitted that they didn't find them guilty, and that they had a reasonable doubt at what was close to 100 days after trial, Your Honor. The court had plenty of time to consider it, plenty of time. If the mind's still not resting easy after 100 days, Your Honor, I think at some point enough's enough. Now, the other thing that we have to look at, Your Honor, is the sufficiency of the evidence in this matter, all right? The sufficiency of the evidence comes into the fact that there was never identified a forged instrument. There were 5 checks that were subject to question due to the 5 counts of the indictment, all of which had the name Rose Gordon affixed to them. There was no debate about whether Miss Rose Gordon signed them. There was no discussion about whether excuse me, I apologize, Your Honor, I have a medication that dries my mouth out. That Ms. Parker had completed those checks. It was all theory, and the court found her guilty based on the testimony of Lloyd Gordon, who co-owned that checking account. Now, if you have 2 owners of a checking account, my understanding at least is both of those have equal access to the entirety of that account. Mr. Lloyd Gordon was also blind and mostly deaf. Mr. Gordon had been in that condition, I believe he testified to, for 40 years. He hadn't done anything with the accounting. He admitted that he had never signed a check. Now, unfortunately, the whole record is replete with over 100 checks signed by Mr. Lloyd Gordon. In fact, the loan from the Gordons to Miss Parker was signed by Mr. Gordon. And then Miss Parker pays it back within 60 days in full from her mother's estate. Now, she took that loan, which isn't in the record, and we don't need to go into it, but she paid it back within 60 days. Now, there's 5 other checks that are all for solid numbers, all cashed at different times over a period of 90 days, all within the means of the Gordon family. And until Lloyd Gordon became responsible for the finances over 90 days after the death of Miss Rose Gordon, there was never any question about those checks. Now, again, Mr. Gordon is blind and extremely hard of hearing. The district attorney had to stand up 5 feet away and yell at him for him to understand the questions, and there was a lot of repeating of the questions. But I think the most important thing that Mr. Gordon said that day, and this is from the trial transcript and in my brief, Mr. Gordon said, "I really don't know what happened. But as far as me knowing, I don't know nothing. I'll just be honest with you. I don't know nothing. There's a lot of things happened, I guess, and I don't really remember it." Now, I don't know how Mr. Gordon would be a qualified person to say that Miss Rose Gordon didn't give consent at that time, especially since it's posthumously. This did not rise while Miss Rose Gordon was in place. There was no record of Miss Gordon saying anything in a dying declaration, excited utterance in her will, even a handwritten document. There was nothing where she said, "Miss Parker stole that money from me." Now, when the court considered this, they also considered a lot of extraneous information, which is commonly referred to as the PayPal accounts. During this, the victim, or I apologize, Your Honor, the defendant testified through her confession that she had exchanged the checks, that she had given her grandmother $4,000, and that she had a balance of about $2,600 left. The total amount of the 5 checks was $1,300, give or take, Your Honor. So her math, as far as on the fly, under pressure, was pretty close. But the state alluded to, and the court found that because the checks were for round numbers, that they must be forged instruments. I don't believe that's an inference that the court can make. Circumstantial evidence is just as valid as direct evidence as long as it's relevant. I don't understand how PayPal transactions, even if Miss Parker did fleece her grandmother for thousands of dollars on PayPal, I don't understand how that's relevant to the specific intent of forgery when she had instruments signed by Miss Rose Gordon that's not in dispute, and there's no evidence that Miss Parker did anything other than go to the store and exchange the check for cash. Now, a blank check is a blank check, Your Honor. I am on the last edge of people who know about checks. I'm on the young end. And the only thing my dad warned me about over and over again when I got a checkbook for the first time, he's like, "Don't go ahead and sign them, and don't ever have a blank check." He's like, because as soon as somebody picks that up, that's a promissory note or equivalent, and that bank has to take it for whatever the value is that they write into it. Now, it's not unusual for grandmothers to distribute money to their grandchildren. In fact, it's very common. Throughout the records that were introduced and throughout the cross-examination of Detective Joey Cox, we went through the hundreds of checks that she had sent to other family members that equated to substantially a lot more money than what Miss Parker had done. The court is relying on a criminal suspicion because remember, if you haven't read the transcripts, the PayPal transactions have no destination. It only shows that there was a PayPal transaction. Doesn't show anything. So I don't understand how we have sufficient evidence to find the specific intent of forgery.
What
I've
about
dealt with many
what about Mr. Gordon's statement that Miss Gordon would not have written checks to cover the defendant's medical bills?
I think it's improper speculation. I don't think that Mr. Gordon had knowledge of what was going on with those finances. I don't think Mr. Gordon, because it was too hard to communicate with him because of his disabled status, had knowledge of how to manage those cases.
Well, you say he was disabled, but he was a competent witness. He was sworn in. The court received his testimony, and he testified that these checks were forged and that Miss Gordon would not have written these for these purposes.
But that's improper testimony because it's speculation. He's speculating as to the mindset of another that he has no ability to. He wasn't introduced as an expert. He's a lay person. And even if it is his opinion, we don't have anything that tends to show the forgery. Now, I'm not saying that Mr. Gordon...
Was his testimony objected to?
It was not.
Well, then it's proof, isn't it?
Well, it is proof, Your Honor.
Well, even if it was objected to and overruled, it came in. And under a sufficiency analysis, we're bound to consider that, and with a guilty verdict to consider it in the light most favorable to the state. So again, what do you make of those statements?
I make of those statements that he testified. I'm asking the court to consider the entirety of his statements. I'm not saying he's an incompetent witness. I'm not saying that the weight was given wrong. He's a credible witness, but he's a fact witness. And the facts are, he didn't know nothing about nothing. Those are his words. He went on to a
That's what he
soliloquy after
said,
being
but he-
questioned about this.
That's what he said, but he also said that he was a co-owner of the account, which I think is undisputed.
Yes, sir.
He said that Ms. Gordon would not have written these, that they were not in the habit of paying for the defendant's medical expenses, and he was the one who reported these as forged checks. So, I mean, with a guilty verdict, we consider everything that he said, including the fact that he said he knows nothing, but you also have to consider the other things in the light most favorable to the state.
No, I understand, but if he had said, I don't think she would have done that, I don't believe that that is sufficient evidence. That's not saying that she didn't do it. That's just saying that he didn't believe she would. I believe he also testified, and it's been a few years, but I believe he also testified that he wouldn't have done it for any of his grandkids. And then the record's also replete with hundreds of checks going to the grandkids. So Maggie Gordon specifically got like 25 checks. So I do consider that as a speculative statement by a fact witness. And, you know, had Mr. Gordon not been blind and come in and said, this isn't Rose Gordon's signature, or, you know, or he had some sort of requisite knowledge of the account. I mean, the essential fact is that 90 days after, or 60 or 90 days after Mrs. Gordon dies, Mr. Gordon, who's blind and deaf, runs out of money in his account. And that's an interesting question. Now, none of Mrs. Parker's checks came in after the death of Rose Gordon. All of those were during her life. There was an...
Well, I was going to say, everything you just told us, I assume was brought out to the trial court.
Yes.
Okay. So if we look at this as we would a jury, they
Yes.
heard all this evidence, and then they still found the defendant guilty, we're going to have to believe, or we're going to have to accept that they made that the court made a determination on credibility and decided that Mr. Gordon was credible and believed his story and discounted the other alternatives.
And I believe that the court would have that to stand on had he not withdrawn that guilty verdict. As soon as he withdraws the guilty verdict, and then when questioned, I mean, we don't have a precedent, I believe, where the juries admitted that they had reasonable doubt and found them guilty anyways.
Did he say, I have a reasonable doubt, or was he just, because I don't really, and again, I've only read part of it, where he was really saying that I have a reasonable doubt. He was asking y'all, I think, for your thoughts on that issue. But I don't get the impression that he had decided, or he said he had a reasonable doubt.
Yes, Your Honor. He didn't say those words specifically, and that's clearly in the record. But when asked a question about reasonable doubt in a courtroom with his experience, and he says, that's kind of what I'm thinking, I think that shows his state of mind. And it's also coming immediately after he's withdrawn the guilty verdict, and there's no other he didn't reopen proof, there's no other evidence to the next 90 days for him to then submit the same thing twice.
Well, you say he withdrew a guilty verdict.
Yes, sir.
So you're saying that the trial judge found on the record, I find this defendant guilty beyond
Yes.
a reasonable doubt, and then sometime down the road said, no, wait a second, I'm setting that verdict aside. I have reasonable doubt, maybe, or whatever
Yes.
the crux of that discussion was. And then later, again, found the defendant guilty beyond a reasonable doubt?
Yes, Your Honor, that's exactly what I'm saying. So on the November 12th, I think it's volume 6 of the record, there was a hearing. There was also a bond revocation hearing because Ms. Parker had committed a secondary offense while on bond. She was detained, and then the judge found her guilty, set her for sentencing, and then a week later, it took a week to get both lawyers back in court. On the 19th, he immediately withdrew the guilty verdict. And while we were discussing his decision and his decision to withdraw, the question was asked of him, does time have a factor here in your reasonable doubt? It took you 90 days to find her guilty, and then within a week, or immediately thereafter, you withdrew the guilty verdict. Now, the verdict doesn't become final for 30 days. I don't think the court had an issue of jurisdiction to withdraw it. The question is, how many signs does it take of a reasonable doubt before we accept that the court didn't have the beyond a reasonable doubt to find guilty? despite
Well,
what
but
it
the court-
says.
But the court, despite what it says, is the court found her guilty and sentenced her. So obviously, at some point, the court was satisfied with the proof and found her guilty.
Yes, sir.
I mean, I think that's what we're dealing with. That's the final judgment of the court, is the sentence, is the act of finding her guilty and sentencing.
Well, then it does become a question, though, of jurisdiction, because if the reasonable doubt that he admits to quasi on November 19th is reasonable doubt, then he's admitted reasonable doubt, and then he withdraws the reasonable doubt to find her guilty with no other evidence and no other satisfying conditions.
But you haven't raised an appellate issue as to jurisdiction or anything procedurally regarding the entry of this verdict. On this point, you're just challenging the sufficiency of the evidence supporting the verdict.
Yes, sir.
So,
But I do
what
think it's
difference
an
does
issue.
it make that there was this procedural wrangling that took place before the final entry?
Well, my understanding is that jurisdiction can be raised at any time.
If it hasn't been presented to the trial court,
Judge, my understanding, the jurisdiction can be raised at any time.
jurisdiction to do what? You saying the trial
Jurisdiction
court,
of the court can be raised at any time. We're on appeal, it's not too late.
are you saying the trial court didn't have jurisdiction to enter this judgment?
The second judgment, yes, Your Honor.
Was there, I mean, the court entered an order or a judgment of not guilty?
Yes, or he withdrew the guilty verdict, but he did not enter not guilty, which is why we say it becomes a question of how much doubt has to be admitted to before a reasonable doubt is asserted, and how much time does it take to find somebody guilty if it's beyond a reasonable doubt?
Well, the ultimate order from the court is, I don't want, he's gonna get into his rebuttal time, so I don't wanna do that to you, but I'm just saying, what we have before us is a finding of guilty by the trial court and a sentence.
Yes,
And you were arguing sufficiency.
yes,
And now we've kind of gone off
into,
into the netherworld of jurisdiction. And, you know, I don't see where the court, if the court had found her not guilty, we wouldn't be dealing with this.
no,
But the court didn't find her not guilty.
that's my question to you.
Well, no, I mean, I'm looking at what we have in front of us.
Well, what we have in
There's
front of
no-
us is sufficiency of the evidence, and there's
Right.
no admittance of a forgery. I mean, if the reasonable doubt admittance by the court is not sufficient to find reasonable doubt, then how is Mr. Gordon's like, well, I guess Miss Parker did it? How is that sufficient evidence to find her guilty? We have no evidence of forgery. We have an allusion to it that he didn't believe she'd have consent, but believing is not evidence. Thank you. I'll surrender the rest of my time, if any, for rebuttal.
All right, thank you, Mr. White.
Good afternoon, Your Honors. May it please the court, Davey Douglas on behalf of the state. This court should affirm the defendant's convictions because the evidence was sufficient to establish that she committed 5 counts of forgery, and there's simply no error with the trial court's entry of verdict. And I'd like to start with the verdict issue and sort of walk the court through what happened. The trial court at a November, I believe it was 12th hearing, made findings of fact and issued an oral decision saying, I find the defendant guilty. But then what we have a few days later is the trial court not withdrawing the verdict. There's no written verdict to withdraw. There's just the oral pronouncement. The court saying, I appreciate you indulging me. I want to think about this a little bit further. And nowhere in that discussion did the trial court say, I have found reasonable doubt. I am withdrawing a guilty verdict. I want to continue to deliberate. The court just simply acknowledged the issue that it was struggling with, and it was how to consider the circumstantial evidence of the defendant's guilt. But this was something that Ms. Parker admitted at the motion for new trial hearing, that the trial court statement during this November 19th hearing was not an admission of reasonable doubt, but that it was just simply acknowledging the possibility of reasonable doubt, which is exactly what a trial court is supposed to consider in a bench trial. And there's also been no authority cited to this court saying that the trial court's procedure that it applied here was improper. But what this court has also said is that the length of deliberations does not affect the validity of the verdict. So here, even if the court did deliberate for a substantial period of time, it doesn't invalidate that verdict. And the issue has also sort of been raised before this court as tying into the sufficiency of the evidence. It wasn't necessarily raised as a standalone claim of jurisdiction or arguing that the trial court never had the authority or jurisdiction to ultimately enter the written judgments of conviction and impose the sentence that it did.
Let me ask you this. The trial court hears the proof and announces from the bench orally, I find the defendant guilty of 5 counts of forgery, or whatever it is. Is there any judgment of guilt whatsoever until a judgment form is signed by the court and entered into the record?
I don't think that there is, Your Honor.
Right, so he basically says, I find her guilty, and then what happens? They adjourn court?
They adjourn, and the trial court's announcement finding her guilty came not at the conclusion of trial, but about a month and a half later. It had asked the parties to submit briefing on the issue of how to consider circumstantial evidence.
Okay, so after all the proof, he just says, I'm gonna take this under advisement.
Yes.
Okay, and then 6 weeks, sometime later, they're in court again, and this time he says, thank you, I've considered it, I find her guilty.
Yes, Your Honor. He made some pretty lengthy findings.
Okay, but none of that was entered into the record at that point.
No, Your Honor, I don't believe that we have anything.
So then some more time passes, and they're in court again, and this time he says, thank you for your patience. I need a little more time to think about this.
Yes, Your Honor, and that also comes after the prosecutor had moved the court to enter a written judgment of guilt. And the
Right.
court granted the motion, but there was no written motion actually.
So at this point in time, all we've got basically is pronouncements that are, until they're written down and entered, they're really not anything.
Exactly right,
Okay.
Your Honor.
Okay, I just want to be sure I was sort of following along how this went. And then finally, a written judgment of conviction was entered, and was that at the same day as the sentencing, maybe?
It was before, so there was a written order from the trial court signed finding the defendant guilty that was
Okay.
issued on March 7th.
Okay,
The sentencing occurred in April, and the judgments, I believe, were ultimately entered in either April or May. But that's what we have here is
Okay.
something
well,
written.
I think I understand Mr. White's point in that, you've got a judge sitting there finding your client guilty, and they're the trier of fact. They're just like a jury. And then next time you hear him saying something, he's saying, I'm not sure, I need a little more time. I'm gonna think about this. And then the next time it's, I'm guilty. I mean, I understand. I mean, if you had a jury who took a case and was out for, trying to figure it out for 6 months, it'd probably still, I understand, it'd still be, whatever they came up with would probably be valid. But you'd also, as a lawyer in the case, would have a pretty good thought that at least one or two of them might have some kind of reasonable doubt during the process. And then, obviously they didn't have reasonable doubt, hopefully, when you get to the guilty verdict. But I just wanted to see if I understood it.
No, yes, sir. And don't get me wrong. This was certainly unusual. This was strange. It was something that I agree with opposing counsel. I've not really encountered it too frequently before. But the fact that it was unusual or strange doesn't rise to the level of the court finding affirmatively reasonable doubt and entering a verdict of not guilty. This ultimately boils down to a really lengthy deliberation, which the trial court was entitled to do as the sole trier of fact here. And in finding the defendant guilty, the trial court properly considered both the direct and circumstantial evidence available to it, and that evidence, when viewed in the light most favorable to the state, is sufficient to support Ms. Parker's convictions. We start first with Mr. Gordon's statements that he and his wife Rose were not in the habit of paying the defendant's medical bills, and that he could only recall Rose writing a check for $15 or $30. Then we have the defendant's statement that, oh, it was authorized for me to write these checks to use to pay off medical bills. There's a circumstantial inference to be drawn that the defendant is lying, that she wasn't in fact authorized to write these checks to pay for medical bills, and that's not what she was doing. These checks were all for round amounts. There were some substantial gaps between the dates that some checks were written and the dates that they were cashed. And then we have the PayPal evidence, which both goes to rebut her her interview with the detective, where she said, no, I only conducted 2 to 4 PayPal transactions. What Detective Cox found was that there were over 20 conducted. So that shows that the defendant is not being truthful about the authorization that she maybe had to cash these checks. And it's also showing that she had access to the account without authorization, because the Gordons didn't have internet. There was circumstantial, Mr. Gordon didn't have a smartphone. He couldn't have set up PayPal himself. It was the defendant doing that, accessing the account. And from all this circumstantial evidence, a rational trier of fact could have found that the defendant was acting without authorization. And there's been a lot of sort of questioning Mr. Gordon's testimony, but that was something for the trier of fact to determine.
I mean, we're talking about, I mean, that's it. Were these checks authorized by Ms. Gordon? And it's a tragic case, obviously, because Ms. Gordon's no longer with us. But is that enough? Is that legally sufficient for Mr. Gordon to come in and say, we were not in the habit of doing that? Is that legally sufficient for a rational trier of fact to find that these particular checks were not authorized? I mean, heaven forbid a spouse would ever write a check on a joint account with their other spouse and not let them know about it. But, I mean, isn't that at least possible on these facts?
It's certainly possible, Your Honor, and I would agree with you. The crux of this issue is whether there was authorization, and Mr. Gordon's statements standing alone, if there was no other evidence, would they be legally sufficient to establish that? I don't know that they necessarily would, but when we couple them with the defendant's affirmative claims that she was authorized to write these checks for medical expenses, and then we don't see really any proof, or we don't see a check that's written to a doctor's office or to a pharmacy or to any medical supplier. We see checks that are written in round numbers. And then we go back to Mr. Gordon's more affirmative testimony that he thought his wife only wrote 1 or 2 checks in the amount of $15 to $30. Again, standing alone, is that enough? Possibly not, but when we look at it with everything else that the state presented, it is sufficient to show.
I'm sorry, does the record show if the checks were cashed or deposited?
They were, I believe the parties stipulated that they were cashed at the bank. Ms. Parker cashed the checks at First Federal Bank. Her boyfriend cashed the checks at a local grocery store. But they were not, I don't believe they were deposited. And that was actually something the defendant claimed that she had put $4,000 of her own money into the account. That wasn't borne out by the financial records. Detective Cox only actually found 1 check that the defendant wrote, and it was for $1,000, the same amount that she had been loaned the month before. And she even wrote loan repayment in the memo line of the check. So the fact that she didn't have the funds that she said she did in the account that she claimed to have been using is further proof that she wasn't authorized to conduct these transactions. And again, this is a largely circumstantial case, but that's what our Supreme Court has said is sufficient to support a conviction. And in cases like this, they often do come down more to circumstantial evidence where, sadly, Rose had passed away before the trial could take place and before the criminal activity could even be discovered. but the proof is sufficient for the trier of fact to have resolved any issues, with any potential issues with Mr. Gordon's credibility. It saw the checks that were introduced into evidence, and it heard Mr. Gordon's testimony, and it resolved any inconsistencies in the state's favor. And we would ask this court to conclude that when viewing the proof in the light most favorable to the state, that it is sufficient to sustain the defendant's convictions, and that there was no error in the trial court's timing of the entry of its verdict. And if there are no further questions, we would rely on our brief for the remaining issues and ask this court to affirm.
I will ask you before you sit down, objection as to relevance was the objection, as I understand it, that was lodged to the introduction of the PayPal transactions in the trial court. What was the relevance of those from the state's perspective?
From the state's perspective, I think it was at least twofold. One, it was relevant to the issue of the defendant's credibility. In her statement to Detective Cox, she had said, I only performed 2 to 4 of these transactions. The proof belied that. It showed that there were over 20. So I think it was relevant to show that the defendant was not being truthful. That's actually something that Detective Cox specifically testified to, that based on his investigation and discovery of the number of transactions, he did not think that the victim or that the defendant was being honest with him. And that was certainly relevant to assess the honesty and veracity of the other claims in her statement. And I think the PayPal transactions were also potentially relevant to the issue of the defendant's motive and intent. This also goes a little bit into the 404B issue that was raised in the brief, but was not the objection that was presented at trial. There was no chance for the trial court to rule on that issue, but I think it could go to show that she was acting with the intent to commit forgery, that she was attempting to, or that she was intending to take money from this account, knowing that she was not authorized to do so, but that she still had control and access to the account. So those are the 2 reasons why I think the PayPal evidence was relevant and was admissible. But again, the only ground that was raised was relevance, and the 404B issue is raised for the first time. And we would ask this court to conclude that it was not error to admit that evidence. Thank you.
All right, thank you, General Douglas.
Your Honor, if I can be brief.
Certainly.
I think I have about 2 minutes left, maybe.
Yes, sir.
3. I don't know. The clock stopped ticking when we were asking questions. Going back to the PayPal evidence and the relevancy of it, it's not uncommon for a grandchild to help an elder family member set up a new technology. I did it for my dad, and I started getting $7 transactions left and right when we'd go out to lunch or whatever. But I don't know how that evidence can be deemed relevant when there's no endpoint for any of the PayPal transactions. In fact, it seems like it's really kind of what falls into the Tottenham United States, in which it's not permissible thus to shift the burden by arbitrarily making only facts which have no evidence of guilt of the offense the occasion of casting the defendant the obligation of exculpation. Now, I asked the detective on the record, did you investigate anybody else for stealing money? Because there was a lot of round number checks to family members. He said no. I asked him if he investigated the bank bank account that Ms. Parker's claimed to have, and that he had a copy of a banknote check right from the cashier when the account finally got turned over because it led us testamentary for the estate of Shirley Montgomery, who was established to be Ms. Parker's mother, and signed by Ms. Parker, that repaid that loan. There's a lot of things that can be also innocuous, all right? A grandmother says, here's a check for $400 that should cover your medical expenses. You don't have to take it to the medical place. You can take it in cash. Maybe grandma's giving her an extra $50. We don't know. We can't establish that without Ms. Gordon. I also don't believe that 5 checks over 90 days would establish a habit of helping out a grandchild. It might be a limited time. It might be extended time. I don't know. The problem is we just don't know. And again, had Mr. Gordon had more of his faculties where he could have seen the accounts, or he could have heard somebody talking about the accounts, or he could have done these things, I think that there would be a bigger argument for relevance by the state. But even now, the state's asking, you know, the record doesn't reflect that. Well, if I give you a check for $4,000 made out to you, you have a choice to deposit it, cash it, take it to a store. Some grocery stores will still let you take a big check in there and they'll give you the balance back. I have no idea what the Gordons did. We have no idea what happened to that check. Later at the sentencing hearing, I introduced certified records of the Montgomery case, and there was a $1,000 deposit withdrawal, and immediately after a $4,000 withdrawal. Now, it doesn't trace exactly to a bank or anything else. It was cashed. But that tends to show that she's telling the truth. And also, I don't understand how she can be convicted of not telling the truth when she was never put on the stand, never put under oath. She was never given the opportunity, she never took the opportunity, other than if they're shifting the burden, which is also in my brief, that because they're using these irrelevant facts. Stealing does not have the same mens rea as forgery. You have to intend to forge. It's a specific intent crime. How does steal, even if she and every other grandchild was fleecing grandmother for thousands of dollars a month, what does that have to do with forgery? And what does that have to do with a third party testifying to speculation that he didn't believe that was happening? Like I heard the court say, Honorable Wedemeyer said, you know, heaven forbid a spouse writes a check a husband doesn't know about. It's a real problem. It's a real issue. And if you take these without the criminality associated with them by Detective Cox, they're innocuous events that don't lead you to believe that it's part of the criminal milieu. Again, PayPal did not go to anywhere. It was just PayPal withdrawals, random. We have no idea where they went. It's not in the evidence. Thank you, Your Honor. I'm out of time.
All right, thank you, Mr. White. All right, counsel, appreciate the